The Gonsalves family wants to appeal the court's gag order, and, well, it wasn't a question of if this was going to happen, only how long would it happen. The murder trial of Alec Murdaugh. Oh, the tangled webs we weave when we try to deceive. Mr. Fucci pleads guilty, and then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for watching. You know the drill. Subscribe if you haven't. Like if you do. Hit that little bell so you receive notifications, and leave me a comment below. And remember, you can listen to us anytime on any of your favorite podcasting apps. Just simply go there and type in Crime Talk with Scott Reich. And today's sponsor is, that's right, CrimeTalkSearch.com. Listen, if you need to find out information about anybody here in the United States, you need to get yourself a background subscription service so you can run that search and get the results literally while you wait and get information as to whether they have a criminal history, whether they're on a registry. Do they have, I don't know, a spouse? Are they divorced? Do they have debts against them? What kind of financial situation are they in? Check them out. Go to CrimeTalkSearch.com. You'll be happy you did. Let's go ahead and open the record for February 6th, 2023. First on the docket, that's right, the Bryan Kohberger matter. The Gonsalves family wants to appeal the court's gag order. So what does this mean? Well, the attorney, a gentleman by the name of Sharon Gray, has entered his appearance. He represents the Gonsalves family. He's represented them for some time, and he's filed an entry of appearance, which is somewhat interesting because now he is a party to this case. But what he is asking for relief from the court is that he says, hey, I'm the attorney. He's licensed in the state of Idaho. He represents the Gonsalves family, and he is filing this motion because he wants to appeal the court's non-dissemination order that the court put in place. He says that it violates the public disclosure requirements that are permitted, and basically it's prior restraint on a lot of the cases that we have previously talked about when it comes to the court's gag order. It is overly broad and inclusive, and what the attorney notes is that there was a hearing held on Zoom and WebEx, and of course they don't tell any of us about it. But on January 12th, he participated in a Zoom call with a magistrate judge, Judge Megan Marshall, in which several of the victims' and witnesses' attorneys were present, as well as the Latah County Prosecutor's Office and counsel for the defendant. In that Zoom call, he informed Judge Marshall that his clients, the surviving members of the family of Kaylee Gonsalves, are not parties to this case and therefore are not subject to the court's order. Seems to make sense to me. The judge, however, stated that she mistakenly believed that they were parties and were therefore subject to the order, and she instructed the attorney to advise them that they were parties. The attorney also informed Judge Marshall that he didn't believe that he was covered under the initial dissemination order, as well as informed her that after the original dissemination order came out, that he emailed the Latah County Prosecutor's Office for clarification regarding the judge's email. They offered no clarification and refused to provide Judge Marshall's email address. During the Zoom call, the attorney informed Judge Marshall that he would be contacting the Idaho State Bar for clarification. Since that amended order came out on January 18th, neither the attorney nor the clients have made any statements. However, he basically says he believes that his clients should be allowed to relay to the media any of the opinions, views, or statements of those family members regarding any part of the case, as they are allowed to speak freely under the First Amendment. Remember, this is government action restricting what somebody can say. There has to be some great compelling reason for this, and it just doesn't seem to make sense. Now, I'm sure the prosecutors are going to ask and say, please don't discuss the case with the media. You don't have to do that, etc. But it really is a First Amendment issue. So the attorney says, hey, I'm not the attorney of record in this case. I've played no part in the investigation. Neither the state nor the defense has shared any information regarding their case, regarding public comments in accordance with the rules as well. And he goes through an analysis that basically said that the cases in Gentile, as well as the ABA rules, specifically Rule 3.6 and 3.8, apply to attorneys who are representing a party in the case, and said that the wording of those rules was vaguely unconstitutional. So this may be the case that gets up there and says, you know what, in today's modern era, we are able to talk about the cases. Yes, the attorneys shouldn't talk about stuff that's going to affect their case. Don't make promises you can't keep. But when you have non-parties talking about the case, I mean, heck, why not just say nobody should talk about this case on YouTube or in the press until the case comes to jury trial? That would be ridiculous. And I don't think the judge has the authority to limit everybody's free speech about the case. We'll see where that goes. It needs to get resolved. But once again, this is what happens when you don't hold hearings. Everything is done via email, and it's done in chambers. Let's see what takes place in an open public courtroom. Let the attorneys make argument. Let's have clarification on that type of information versus this I don't even know what to call it, this trial via chambers. I just don't get it. So I hope the family's attorneys prevail on this just for the fundamental principle of free speech. Let me know. Do you think they should be required to keep their mouth shut? I don't think the court has jurisdiction over them because they're not a party to the case. Just saying. All right. Now, we knew this was going to happen. It was only a matter of when. But yes, meet this woman, Brittany Highslope. Well, apparently she has written a series of Facebook posts professing her love for the accused murderer of the 4 college classmates. She is gushing that Kohberger is the perfect man in her life. In one post, Highslope said, "My love interest is named Bryan and is accused of murder, and I just wish to connect with him above anyone else." She states in her post that one way to describe her feelings for him over the last week or so is kind of like being lovesick. Now, Highslope started posting her passionate letters to Kohberger on January 4th, just a few days after he had been arrested at his parents' home in Pennsylvania for the murders. The single Kentucky mom, who has a 16-year-old son, pointed out that she and Kohberger shared some things in common, such as their astrological signs, both apparently Scorpios. She also claimed they've had similar birth charts, making Kohberger her divine masculine counterpart. And Kohberger has been charged, obviously, with the murders of Kayla Gonsalves, Madison Mogen, Zana Kernodle, and Ethan Chapin. He's denied any wrongdoing. The matter is set for a preliminary hearing on June 26. So, what does that mean? I don't know. I just do not get it. I understand it's a very low standard for dating these days, but when you're looking at spending the rest of your life in prison and possibly death, I just don't see how that would be a great match made in heaven. Maybe if you want a relationship where you never actually really have to get to know somebody, that's the perfect way to do that. That's just weird. I don't get it. I never understood it. I just don't get it. Makes no sense to me. We saw it in the Chris Watts case. Heck, we see it in every case whatsoever. All right. Next on the docket, the Alex Murdaugh case. Oh, the tangled webs we weave when we attempt to deceive. So after nearly 2 days of in-camera hearings with the jurors outside the presence of the courtroom, Judge Clifton Newman has ruled evidence pointing to Alex Murdaugh's alleged financial crimes are in fact relevant to the double murder trial. Judge Newman said he feels the evidence is relevant through its potential to shed light on a potential motive for the murder of Maggie and Paul Murdaugh, and under the law in the state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. That's right, 404A and 404B under the rules of evidence. However, the judge said the exception exists when the evidence is presented to show motive, intent, the existence of a common scheme or plan, and the absence of mistake or accident. Prosecutors have argued throughout the trial that Alex Murdaugh's declining finances may have motivated him to actually take part in the killing of his wife and son. Part of Newman's decision, he said, was based on the fact that Murdaugh was preparing for a June 10th, 2020 hearing on the disclosure of his financial records, and the judge said that they may have revealed Murdaugh was allegedly stealing millions from his own clients, lawsuit settlements providing a potential motive, and evidence of malice. Now, Newman had previously said defense attorneys opened the door to the admissibility of financial evidence by asking witnesses if they could think of any reason why Alec Murdaugh, who they've called a loving husband and father, would ever want to kill his wife and son. Well, then after that ruling, there was a witness on the stand by Michelle Shelley Smith. She goes by Shelley. She's the caregiver for Alex Murdaugh's mother, and she was called as a witness. And she said that she started working for the Murdaugh family back in October of 2019, and she also looked after Murdaugh's father, Randolph, every now and then. Now, Miss Smith, like I said, was the caregiver for Alex Murdaugh's mother the night Maggie and Paul were found shot to death. And she said that it was unusual for him to visit his mother late at night. She said she'd worked for the Murdaugh for nearly 2 years and typically looked after Murdaugh's mother overnight from 8 p.m. to 8 a.m. She told prosecutors that Mr. Murdaugh stayed at his mother's home for about 20 minutes before leaving. And then on the day that Randolph Murdaugh's funeral was taking place, Ms. Smith was there as well. And Alec Murdaugh told her he'd been at the house for his mother 30 to 40 minutes on the night that Maggie and Paul were murdered. Hint, hint, wink, wink, nudge, nudge, say no more, say no more. That's right. Certainly the way it sounds. He apparently came in the room and spoke with his mother, like they always do. And then Miss Smith said, what did he tell you? The prosecutor asked, and Smith took a brief pause and began tearing up before answering that he was at the house, Smith finally said, referring to his mother's house. And what was he telling you about the night that he was at the mother's house when the murders took place? That he was there for 30 or 40 minutes. Hint, hint, wink, wink, nudge, nudge, say no more, say no more. We know, come on. I was here for 40 minutes, remember that? That's right. Earlier, obviously in the testimony, Smith said that he had only been at the house for about 20 minutes to visit the mother. There was a little bit of controversy when Smith previously testified. She saw Alex Murdaugh carrying a blue tarp into his mother's home. In the days after the murders of Paul and Maggie. Early in the trial, prosecutors said they located a blue wadded-up raincoat in a closet at Alec Murdaugh's mother's home. That coat had gunshot residue on the inside, according to the prosecutors. And then Griffin, on cross-examination, unpackaged a large blue tarp before the witness stand, unfolding it. You know, the big blue tarps, the kind that you go camping with or you cover your car with. And she's testified that that's what he came to the house with that day, and not anything like he was carrying a shovel or a firearm or anything of that nature. And she agreed. Now, Mr. Murdaugh also agreed to help Miss Smith with some finances. She was getting married, and about the same time he's willing to help her out getting married, hint, hint, wink, wink, nudge, nudge, he was there for 40 minutes. Just something to think about. Something to think about. It's all kind of coming together. Anyway, well, the court resumed later in the afternoon regarding this blue raincoat. And before jurors returned to the courtroom, defense attorneys Jim Griffin rose and asked Judge Newman to exclude evidence related to the blue raincoat with gunshot residue, being that the state had seized it from Alex Murdaugh's mother's house. Griffin argued since Miss Smith's who's the caregiver, was on the witness stand, only testified she saw Murdaugh carrying a blue tarp and not a raincoat, that there was nothing linking Murdaugh to the coat. And then there was an issue where Judge Newman announced that one of the jurors has raised concerns that a trial could take too long to resolve, and they may not be able to remain on the jury for the duration. As you may recall, the trial was originally stated that it was going to end by February 10th, but the admission of a lot of the in-camera testimony that took at least 2 days is likely pushing this trial into the next week. Of the 255 witnesses named before the trial began, 35 have taken the stand so far. The jury has only heard from 27 witnesses, as 8 delivered their testimony during the in-camera motion hearing to admit financial evidence into trial. So we have to listen to that all over again. And then right before we were finishing up this video, Kristen Moore, a SLED investigator who executed the search warrants at Alec Murdaugh's mother's home, has taken the stand. Moore said that she and other agents went to the scene and were told to search for a blue tarp-like object, which they recovered from a closet. Underneath were miscellaneous dishes, she testified, and they recovered a blue raincoat in a different second-floor closet. Now, the investigator said no blood was found on the blue raincoat that was discovered after multiple tests, and although some latent stains were discovered under an alternate light source, Moore testified that none were identified as blood. Next on the docket, remember Aiden Fucci? That's right, the Florida teen accused of stabbing a classmate more than 100 times on Mother's Day in 2021. Well, his trial was scheduled to begin this morning, and he pled guilty to first-degree murder. Aiden Fucci is only 16 years old. The trial was set to begin, and he wanted to change his plea, proceeding with a guilty plea. He was charged as an adult for luring a 13-year-old Tristan Bailey into a wooded area on Mother's Day of 2021 and killing her. He was arrested the day after Bailey was found deceased, and the state's attorney said that Fucci had told friends he intended to lure someone into the woods and kill them, but no one came forward until it was too late. In court, Fucci asked to make a statement after changing his plea, saying that he wanted to apologize to the Bailey family. Fucci told the circuit court judge, R. Lee Smith, that he understands the decision he made and he's had time to talk it over with his parents and attorneys, one of whom noted that prosecutors had rejected several plea offers from the defense team. Smith noted it was a straight plea deal, not negotiated with the prosecution. A sentencing hearing is expected sometime in March or April. Fucci faces a possible sentence of 40 years to life in prison. Finally, our undone criminal of the day. U.S. Coast Guard crews rescued a boater in distress just as his boat capsized in the surf near Cape Disappointment on Friday. According to the police in Astoria, the boater, 35-year-old Jericho Labonte, is accused of stealing the boat. He is also suspected of leaving a large dead fish on the porch of the Goonies house. Now, according to the Coast Guard, 2 air crews were on training missions at the mouth of the Columbia River when they received a mayday call from a boat that was floundering in the surf. A boat crew was also called out from the Coast Guard station at Cape Disappointment. However, the surf made a boat rescue too dangerous, and United States Coast Guard officials decided to lower the rescue swimmer who was on his first rescue and have Labonte enter the water. Just as he jumped into the water, the vessel capsized. The rescue swimmer was able to safely get Labonte, who was flown back to the Astoria Coast Guard base for medical evaluation. He was released around 3:30 p.m. as authorities noted that they did not know that at that time the boat was stolen. Police were notified about 4 p.m. that the boat was in fact stolen from the Astoria port. Police found Labonte at a warming shelter in Seaside where he had used a fake name. They arrested him about 7:30 p.m. Now, officers had been looking for him since Wednesday when an acquaintance alerted them to the video that he had posted on social media of himself leaving the fish at the Goonies house and then dancing around the property. You know, the movie Goonies? Anyway, Labonte has 5 outstanding warrants in Victoria, British Columbia, and the Royal Canadian Mounted Police are headed to Oregon to question and arrest him. Okay, one thing, Mr. Labonte, when you're a criminal and you're basically on the run, low profile, buddy, low profile. Don't get highlighted where your video basically goes viral because the boat is completely destroyed as it gets tossed completely in circles over the surf, and then you stole the boat. Dude. Bad, bad, bad. Anyway, all right, that's all we have for you today. Just remember, if you got those warrants, hang low. Don't highlight yourself. Have a wonderful day. We'll see you next time on Crime Talk.